Good evening, Malaysia. On tonight's episode, we will be discussing sex crimes against children. Children are the most vulnerable members of society, and any sex crimes committed onto them will cause long-lasting and devastating consequences. Therefore, it is imperative that laws protect children from all forms of sexual abuse. Our penal code in Malaysia has some laws to protect children. However, it is somewhat inadequate and outdated with respect to digital sex crimes. Therefore, the passing of the Sexual Offences Against Children Act 2017, or SOACA, was an important addition to protect children both physically and online. On tonight's episode, my team and I will discuss the adequacy of laws in protecting our children. We'll first give a general overview of the law before narrowing down the discussion onto 4 types of sex crimes against children, namely sex crimes involving penetration, sexual assault, child pornography, and offences relating to child grooming. But before we move on to analysing the law, we must first address a very important question. Who exactly are the children? Under the SOACA 2017, the definition of children is provided in 2 ways. Firstly, children are any persons under the age of 18, and for the purposes of prosecution, it is irrelevant whether the accused believed that the child was over 18 unless they took all reasonable steps to determine the age of the child. Secondly, children are any persons believed by the accuser to be under 18, even if the person was actually not a child. In my part of the video, I will be analysing sex crimes involving penetration against children. One way to understand this offence in Malaysia is to classify the offence into penetration with a penis and penetration with objects. For penetration with a penis, Section 375G of the Penal Code provides that it is rape if the accused has sexual intercourse with a person under the age of 16, regardless whether consent was given or not. Therefore, there is an implied presumption that children below the age of 16 cannot consent to sex. However, Section 375G only applies to offences involving penetration of a vagina with a penis. In the cases which involve penetration of the anus or mouth of the victim with a penis, it is then an offence under Section 377A of the Penal Code, and this is regardless of consent or age of the victim. In short, all forms of penetration by the use of a penis against children under the age of 16 is criminalised under Malaysian law. On the other hand, the offence of penetration with an object is covered by Section 377CA of the Penal Code. It provides that it is an offence to have sexual connection by introducing an object into the vagina or anus of the victim without their consent for that purpose. The important factor to note here is that Section 377CA requires that the victim to have withheld consent in order for the offence to be established. Thus, this implies that it is not a crime to introduce an object into the vagina or anus of a child, so long as they had consented to the act. The law here is unsatisfactory, because the presumption that children below the age of 16 cannot consent to sex is disregarded by Section 377CA. In other words, it appears that children under 16 cannot consent to penetration with a penis, but they can consent with penetration with an object. In England, sex crimes involving penetration of the vagina, anus, and mouth of a child with the use of a penis or an object is criminalised under Section 5, 6, and 9 of the Sexual Offences Act 2003. In practical terms, this means that the law in Malaysia and the law in England provide for the same types of offences. The only difference is with regards to the punishment for these offences. Nonetheless, there is one offence provided for that is exclusive to English law. It is the offence of inciting a child to have sexual activity with a third party, as provided by Section 8 and 10 of the Sexual Offences Act 2003. There is no direct equivalent of this offence under Malaysian law. Thus, if say Spider-Man here incites a child to have sexual activity with say Ironhide the Transformer, then only Ironhide will be prosecuted under Malaysian law. Meanwhile, Spider-Man gets off scot-free and can away. In this regard, it is submitted that the law here is not sufficiently strict, and that this omission should be criminalized by Parliament so that every individual involved in a child having sexual activity would be punished, and this would form an effective deterrent.
In Malaysia, sexual assault on children takes two forms, which are physical and non-physical sexual assault. Both are governed under Section 14 and 15 of the SOACA 2017 respectively. According to Section 14, any person who with sexual purposes touches a child's body or makes the child touch his or other's body or does any acts that involve physical contact without sexual intercourse commits an offence of physical sexual assault. It is submitted that this provision under SOACA is more superior than the English SOA as it covers multiple forms of touchings. It can either be direct or indirect. It also includes for cases whereby the children were meant to touch themselves or others. Although Section 7 and 9 of the English SOA concludes that sexual touching may amount to sexual assault, it does not provide for situations as such. However, since the physical element in Section 14 has been broadly defined, the question now turns to whether the accused acted for sexual purposes. Unfortunately, SOACA does not define sexual purposes, but there seems to be a solution to this if the law is to be applied sensibly with Section 354 of the Penal Code, assault with the intent to outrage modesty, as the requirement for intention for both of these offences are quite similar. And plus, this provision provides for sexual touchings that fall short of penetration. In contrast, the term sexual has been explicitly defined in Section 78 of the English SOA. Besides, there are also some difficulties with Section 14 subsection D of SOACA that refers to any acts that involve physical contact without sexual intercourse. First, it is very difficult for us to know what will be covered by the physical contact that is not already covered by the word touching under other subsections. Secondly, it specifically excludes sexual intercourse but other subsections do not. Therefore, it is arguable that Section 14 subsection A, touching a child's body with the accused body, could be interpreted broadly to include penetration of vagina with a penis. Whereas for the UK, Section 79, subsection 8 of SOA clearly defines touching and it includes penetration as well. As for non-physical sexual assault, Section 15 covers harassment by uttering words or making sounds, self-exposure and even stalking with sexual purposes. Similar to Section 8 to 12 of the English SOA, it also includes offences such as engaging in a sexual activity in the presence of a child and causing a child to involve or watch a sexual activity. The accused need not have the sexual purposes to commit this crime. Since sexual motives are not required, the question of whether the act is sexual in nature is now critical. Once again, SOACA does not explain to what extent will an act become sexual, considering the fact that passionate kissing with consent between adults might not be sexual, but making a child to give a passionate kiss to an adult or other children might be regarded as sexual in nature. Since both jurisdictions fails to explain this, it is very important to take into account of indecent assault. Malaysian jurisdiction seems to offer a broader protection for children, as the court could always resort to Section 377D and E of the Penal Code, whereby the commission of indecent acts is an offence. In the case of Sukma Dharmawan, it is left to the court to decide what constitutes indecency, considering an individual's cultural, family, and religious values. Comparatively, in the UK, the legislature seemed to prefer the term sexual over indecent after the provisions that talk about indecent assault in SOA 1956 had been removed. Besides, in the English SOA, there are different provisions for children under 13 and 16 for the similar offences. The reason is that all offences that involve children below 13 are strict liabilities. For children under 16, the prosecution would have to consider the issue of reasonable belief. In contrast, SOACA is silent on both belief and consent. Presumably, mistake in belief and consent is not a defence for these offences. Moreover, SOACA also does not indicate the situations whereby child sexual assault are committed by young offenders below 18 years old, whereas this is provided in Section 13 of SOA. Thus, compared to the UK jurisdiction, it can be deduced that SOACA, if applied sensibly with the penal code, is sufficient to criminalize sexual assault against children, except for the problems with Section 14 subsection D and situations whereby young offenders are involved.
We'll be discussing on the adequacy of child pornography laws in Malaysia. The Sexual Offences Against Children Act 2017 casts the net rather widely in defining what child pornography is. The 2017 Act criminalized all acts related to child pornography industry and also provides a higher standard of protection to children. It is commendable that the scope of the SOACA is all-encompassing and comprehensive. It criminalized mere possession as well as acts of seeking, accessing, making, producing, importing, and exporting of child pornography. To put it in simpler terms, almost every activity in relation to child pornography is forbidden and prohibited under the law. The term child pornography is clearly defined in Section 4 of the SOACA. The definition is very comprehensive because it covers all kinds of representation of a child. For example, it includes a person appearing to be a child or even realistic or graphic images of a child engaging in sexually explicit conduct. It has been suggested by academics that this wide definition may encompass cartoons, computer-modified images, or any images which appear to be a child or involve the participation of an actual child. In this aspect, likewise in the UK, in October 2014, a man by the name of Robert Hook was convicted of possessing illegal pictures of cartoon children in the Crown Court. Robert Hook is believed to be the first British man to have been convicted based on manga or anime-style images alone. In handing down the sentence, Judge Tony Briggs said that the images seized from Hook's computer were clearly all designed to make people think they are of children, and this is material that clearly society and public can well do without. Although Hook did not victimize any real children, Briggs claimed that the more is portrayed, the more the ill-disposed may think is acceptable. The term sexually explicit conduct is further clarified in Section 4 of the SOACA, where it is referred to as the actual or simulated sexual intercourse, lewd acts, bestiality, masturbation, sadistic or masochistic abuse in a sexual context, exhibition for sexual purpose of the genital, buttock, breast, pubic area, or anus, and the use of instrument for lewd acts. Instead of using the term child pornography, the law in England and Wales, under Section 1 of the Protection of Children Act 1978, adopted the notion of indecency. However, the term indecent is not defined in the statute, and therefore it has been left to the courts to establish the term. Therefore, it can then be concluded that the Malaysian law is more adequate than the English law in this aspect, as it provides a statutory definition of the term child pornography, unlike the law in England and Wales, which relies on a rather vague term of indecency. Malaysian law is also adequate in the sense that it provides adequate penal sanctions. Section 5 of the 2017 Act imposes a maximum jail sentence of 30 years and the reception of not less than 6 strokes of whipping upon conviction for the making, producing, directing the making, or production of child pornography. Section 6 penalizes the making or production of child pornography with imprisonment not exceeding 10 years and whipping. Section 7 imposes a maximum imprisonment term of not more than 20 years and whipping not less than 5 strokes for using a child in the making or production of child pornography. Exchanging or selling child pornography are addressed in Sections 8 and 9, penalizing the offenders with a maximum jail sentence of 15 years and whipping. Anyone who is convicted under Section 10 for accessing child pornography shall be liable for imprisonment for a term not more than 5 years and 10,000 ringgit fine. Nonetheless, despite its adequacy, the provisions relating to the access of child victims to compensation is silent in the SOACA 2017. A direct access to a state fund where the procedures will be purely administrative should be established. For example, the establishment of the Criminal Injuries Compensation Scheme in England, Scotland, and Wales. Moreover, state fund will be the best alternative in assuring financial assistance for the victims to undergo physical and mental rehabilitation services in the event where compensation is infeasible. Therefore, it can be said that SOACA 2017 is a significant milestone in the Malaysian law in protecting children against child pornography. The Malaysian law is more adequate than the law in England and Wales in the sense that it provides adequate penal sanctions, wide definition of child pornography, as well as criminalizing all acts related to child pornography industry, despite the lack of provision relating to the access of child victims to compensation. Also, The Malaysian laws need to make some defences available, like the law in England and Wales, as there may be a number of legitimate reasons as to why one would be in the possession of child pornography. Inevitably, the police and prosecutors are required to have the materials for the purpose of investigation and prosecutions. Defense lawyers need to have the same to defend their client. Moreover, welfare officers, children protection teams, and others may need to be in possession of these images as well.
I will now discuss the relevant section under the Sexual Offences Against Children Act SOACA and the Sexual Offences Act that provides for the offence relating to child grooming. At the same time, making a comparison between both laws to address the adequacy of the laws. Then, at the end of my speech, I will be explaining on abuse of position in relation to the sexual offences. In brief, the offence of child grooming can be broken down into three aspects. Firstly, sexual communication with a child grooming, and meeting following the grooming. Under the Malaysian law, Section 11 of the SOACA provides for the offence of sexually communicates with a child. Any person who sexually communicates with a child or encourages a child to sexually communicate will be deemed to commit this offence. Such communication must be sexual in nature or deemed to be sexual by a reasonable person. On the other hand, Section 15A of the Sexual Offences Act provides for a similar offence. However, under this section, such communication must be done for the purpose of obtaining sexual gratification, and the offender must be the age of 18 and above. After comparing both sections, we can fairly conclude that the Malaysian law is less comprehensive than the English law in many ways. Firstly, Section 11 of the SOACA fails to specify the minimum age of the offender, whereas English law provides that the offender must be the age of 18 or above. Confusion may arise as it is unclear whether the offender under the traditional age of 18 could be charged under this offence. Secondly, under the UK law, the law merely requires on the intention of the communication with the purpose of obtaining a sexual gratification. So in short, the conversation between person A and person B does not have to be sexual in nature as long as the communication was made with the intention of procuring the sexual desire of the child. On the other hand, SOACA requires the content of the communication itself to be sexual in nature. As such, there is a heavier burden of proof that lies on the prosecution to prove that all elements are beyond reasonable doubt. And if the prosecution fails to do so, the offender could possibly escape from their liability. Lastly, under the SOACA, several uncertainties has arisen as it is unclear what act actually falls under sexual in nature, which is the key to proving criminal liability. As pointed out by Jasmine just now, the term sexual was not defined under the act, and therefore the law is potentially of a very wide scope. So now, moving on to child grooming. Child grooming is a gradual process where a pedophile builds trust with a child from a non-sexual relationship to a sexual relationship in a manner that seems so natural and non-threatening. Unlike sexual communication under Section 15, child grooming involves building a healthy relationship with the child for the purpose of taking sexual advantage of the child that suffices to be an offence under the Malaysian and the English law. The offence of child grooming is covered under Section 12 and Section 13 of the SOACA and Section 15 of the Sexual Offences Act 2003. The main difference between the Malaysian law and the English law is fairly evident. Unlike the Malaysian law, the English law provides no express section that covers child grooming specifically. According to Craven and Brown, the UK legislation has been criticised in capturing situations where the offender is already physical proximate to the child and does not actually have to travel to meet the child. However, such concern only lies in the English law, as the Malaysian law has an additional section, which is Section 12, to tackle issue as such. On the other hand, both the Malaysian and the English law has been criticised in failing to provide a clear definition of grooming. The absence of a clear definition of grooming generates a very wide scope of discretion for the courts to define what actually amounts to grooming. But regardless, by comparing both the Malaysian law to the English law, it can be deduced that the Section 11, Section 12, and Section 13 of the SOACA is sufficient in criminalising child grooming, as it covers a wider range of circumstances as compared to the English law. However, minor reform does have to be made to provide a clearer scope to define what actually amounts to sexual act, child grooming, and possibly the age of the offender. I will now move on to discuss the offence in circumstances where there is an abuse of position under a relationship of trust. The relevant laws are covered under Section 16 to 24 of the Sexual Offences Act under the English law and Section 16 of the SOACA, which imposes a heavier punishment for the offender. Under this section, the English law is fairly more comprehensive as it actually defines what relationship of trust is. On the other hand, the Malaysian law provides for a non-exhaustive list under Section 12, Subsection 2, which provides great flexibility for the law to expand and to include different types of relationship. Therefore, from above, it is fair to conclude that the Malaysian law is adequate to a certain extent in protecting the child against the offender.
Although the implementation of the Sexual Offences Against Children Act 2017 is a step forward in curbing sexual offences against children, a few loopholes remain in the current legislation. Firstly, the law seems to criminalise touching, regardless of whether consent was given. However, consensual sexual intercourse for children aged 16 and above is allowed, which is a far more serious offence than the offence of physical assault, if you think about it. It is therefore hard to reconcile as to why a far less serious offence such as physical and non-physical sexual assault are criminalised, but not consensual sexual intercourse. Secondly, the SOACA is also silent on the issue of child marriages, whereby child marriages may be used as an escape route for child sexual offenders. As mentioned previously, assaulting or sexually touching a child is illegal, but when the parties are married, having a sexual relationship does not fall within any of the provisions under the SOACA. This loophole can clearly be seen in Section 375 subsection G of the Penal Code, which criminalises sexual intercourse with a child under 16 years old. But if a child was married, the accused will not be found guilty. In essence, child marriages can bypass the law in this sense, as the exception to this provision provides that sexual intercourse between a married couple cannot constitute as rape. In other words, consent to marriage is also consent to sexual intercourse, and as long as the marriage is in existence, this right to intercourse cannot be revoked. Various women's groups have argued that by giving such immunity, the marriage license can indeed be called a license to rape. Therefore, even if a girl in child marriage does not consent to her husband engaging in sexual intercourse with her, no recourse is provided under both the Penal Code and the SOACA to allege rape at all. Therefore, it is significant to note that marital rape is indeed not recognised in Malaysia, unlike in the UK, whereby it has been confirmed in the House of Lords case of R against R that marital rape exemption forms no part of the law of England. In socially conservative societies, it is common for underage rape victims to be pressured into marrying their rapists in order to bury the case. Otherwise, the girl's name will be tarnished, more so if the girl becomes pregnant with a child and the child will then be regarded as illegitimate. For example, there was an infamous case of Ahmad Shukri Yusof in 2016 where the man who was charged with raping a 14-year-old girl was spared from being sent to prison and possible whipping after he married the teenager. This is an example of a recent case where child rapists tried to use marriage as a means to escape punishment. However, fortunately for this case, the High Court later reinstated the statutory rape charge against the offender due to public outcry, which the session courts had dismissed earlier on the grounds that the victim withdrew the rape charge against the offender. On this note, there seems to be a glimpse of hope in the efforts of the courts in preventing the use of this loophole to the advantage of the child rapists. Nonetheless, a clear provision, possibly under the SOACA, is still required in order to successfully curb this issue of child marriages, which involves child rapists marrying their victim in order to evade punishment. Moreover, the lack of an existence of a standard minimum age requirement for the victim of some of these offences has been deemed problematic. Under the SOACA, a child is defined as a person under the age of 18. Confusingly though, SOACA does not change the ages applicable under other legislations. For example, the Penal Code specifies the minimum age of 16 years in the context of rape, 12 years in the context of assault with intent to outrage modesty, and 18 years for voluntarily causing hurt. Not to mention, the Act fails to refer to the type of perpetrators that may be involved in child sexual exploitation. For example, especially in cases of child pornography, there could be an individual or group that could be committing the offence. Who then will be responsible for the offence? In conclusion, although it can be said that the SOACA is well equipped with many procedures to combat sexual crimes against children, including setting up a special court for child sexual offence and introducing new offences against children, such as child grooming and child pornography, nonetheless, there still exists some ambiguity within its provisions, which may hinder its application. Although Malaysia has ratified the Convention on the Rights of Child, also known as the CRC, court decisions, especially the Sharia courts, are more often than not decided in contravention of this international convention by allowing females under the age of 16 to be lawfully wedded under the Muslim law. Therefore, it is our hope that the country will take these issues into considerations in order to achieve a progressive society.